The two Rastafarian students denied admission by the Achimota school for keeping their dreadlocks will have to stay home until a case they have filed in court challenging the school's decision is determined. And Accra High Court, as the Human Rights Division today, dismissed an application for interlocutory injunction filed by one of the Rastafarian students denied admission by Achimota School, Iras Magwai, which was seeking to restrain Achimota School from carrying out its decision to not admit them. According to the High Court judge, Justice Gifty J. Ado, the application for injunction, if granted, could prejudice the entire suit before her. But father of one of the children, Ras Aswad and Krabia, says even before the court rules on the substantive matter, they have started giving their children education from home.
He's already started his education online, and there are individuals that come in the house to actually give him some teaching. Remember, he was taught at home before he did the homeschooling, right? So that is not new to us in terms of keeping him up to the level so that when the exam comes, he will be able to deal with it. But it is necessary for us to pave the way for future generations of Ghanaians, because as my sister just said, a whole colonial law in this time is using to disenfranchise Ghanaians with impunity. It is necessary for us to ensure that this doesn't happen in the future.
Ras Aswad and Krabia adds that they will continue to follow the case until, as they put it, justice is served.
No, I'm well pleased, and the reason why I'm well pleased, instead of putting the child through this 10-day issue of determining the judgment in terms of whether he goes back to school or not, you know, wasn't really the best, and it's not really the best for 10 days, and then the next 10 days you have to, you know, redo the whole situation. So giving us that 7 days to serve, and then from there we begin the process, I think is the best solution. So I am in favor of that direction.
When it comes to this whole substantive matter of getting the child enrolled in Achimota School, is it? I remember in the past you said that you are not even interested in them going to the school any longer, but now we are in court seeking such a relief.
Yeah, you see, it's not really going backward, you know. As you move along and the realities unfold, you recognize that your strategy must change. When we look at the appeal in terms of from the Ghanaian society in general, when they look at it and they see the level of discrimination, the society in general is calling for justice. The society in general is saying that justice must be served, right? So if we walk away from it today, we would actually defeat injustice. So it is important for us to fight this battle to ensure that not just my child, not just the two children, but all Ghanaian children have a right to education based on what the Constitution has given them.
Meanwhile, a member of the legal team of the Rastafarian student, Ras Wayo, says they will comply with the court order to serve Achimota School immediately for the substantive case to be heard.
Technically, this ex parte motion, even if it is granted, it extends for 10 days. So in 10 days, we would have come for a repeat application where we have to go on notice. Where on notice means we serve the other parties. The ex parte means that we came to court without the other party. So that's the dynamics. If it had been granted, it would have lasted for only 10 days. So the court would have just said, okay, take the children to Achimota School, and after 10 days, Achimota School can say, okay, your stay here is 10 days, so go back and go and repeat the application. The timelines and all those dynamics. So the judge, in view of that, and also indicating that the first respondent, which is the Board of Governors, that is Achimota School, has not been served the substantive application itself. And so her thinking is that she will want to deal with the matter in an expeditory manner so that the case will move in respect of the substantive application itself. So this application will be refused. However, in order to speed up the trial of the substantive application, which is the application, which is the meat of the matter on enforcement of fundamental human rights, that is the main application, not this one. She wants to speed up and get to that application so that the child will not be at a disadvantage. So she's ordered that we serve this ruling that she's just given on all the parties. And then the parties, normally the rule says you have 21 days to respond. But by her order, when we serve this ruling on the parties, that is the respondents, that is the Achimota School, the GES, Ministry of Education and Attorney General, when we serve today's ruling on them, they have only 7 days and no more 21 days. The rule says 21 days, but the judge is saying that because she wants to deal with this substantive matter itself, the enforcement of human rights. That's what she wants to deal with, and not take somebody in for 10 days, and then after 10 days, you come back again for another application. So in her mind, she's not too convinced, especially when the Achimota school has not been served with a substantive matter.
As lawyer for the Rastafarian students who have taken the matter to court.